Hello, my name is Grant Toeppen. I'm an estate planning and probate attorney based in Manteca, California. My law firm is Advanced Planning, a law corporation of which I am the sole proprietor. So this video, we are going to unpack limited conservatorships. I've carved a bit of a niche out for myself in doing limited conservatorships. I end up helping out a lot of families with these. And so many of them come to me just because they were referred by maybe a case manager at a regional center and they don't really know what's going on. But the fact pattern is typically as follows. They come to me with a developmentally disabled child. It's usually the parents who come to me. They have a developmentally disabled child who's about to turn 18, aka hit the age of majority. And the parents find out they can no longer make decisions for their developmentally disabled child once they hit 18 because they're legally an adult, and the California Probate Code, California law, presumes that adults have mental capacity. But with developmentally disabled individuals, sometimes they do have mental capacity and other times they need assistance in making everyday decisions such as medical decisions, such as where to live, what educational programs to go to, whether to enter into or exit out of contracts, etc. So the parents have been making these decisions for the developmentally disabled child, basically for that child's whole life, and now everything's about to change once they hit 18. So a limited conservatorship is the process by which we petition the court to make it so that the parents, or it can be a sibling, it can be anybody really who plays a major role in this person's life, we petition the court to make it so that this individual, the petitioner, the proposed conservator or proposed conservators, as you can have co-conservators. I've actually had up to 6 at once, so you can have a lot. So they are basically going to ask the court to make decisions, usually medical decisions, decisions concerning education, decisions concerning contracts, confidential papers, etc. They're going to ask the court for the ability to do this, and a limited conservatorship is the process by which this is done. So it's called a limited conservatorship because these types of conservatorships are limited to only being available for developmentally disabled adults. And the public policy behind these types of conservatorships is we want this individual to fly free, so to speak. We want them to be able to make decisions on his or her own and live on his or her own one day. So we try to edge on the side of giving this individual freedom when appropriate. But at the same time, sometimes individuals are just going to need help for the rest of their lives. And that just is what it is. And it's still called a limited conservatorship, even if the public policy is that this individual manage their own affairs. Sometimes that's just not realistic. So within limited conservatorships, there are 2 subtypes. There are conservatorships of the person and conservatorships of the estate. I find for limited conservatorships, conservatorships of the estate are fairly rare. These are managing the money and assets of the proposed conservatee. Most developmentally disabled individuals I've dealt with do not have substantial assets. Their parents have managed all of their assets for their entire life. So a conservatorship of the estate is rarely necessary. I've dealt with these for limited conservatorships in a few limited situations, mainly if the child has perhaps inherited a large amount of money, or perhaps the child has some sort of business, or there's some other financial concern. We want to make sure that the finances are locked down extra tight. But most of the time we do a limited conservatorship of the person. There are 7 broad categories for limited conservatorships of the person. I typically ask the courts for 5 of these, and you'll see why when I explain them. So the typical 7 powers are the ability to control the conservatee's contracts, make medical decisions for the conservatee, choose the conservatee's residence, the ability to choose the conservatee's education, the ability to have access to his or her confidential papers, and then the other 2 are limiting the ability of the conservatee to get married and limiting the social and sexual contacts of the proposed conservatee. The last 2 were really rarely get granted unless there are obvious facts that this conservatee is being taken advantage of by people, and then we might want to limit their sexual, social contacts, limit the ability for them to marry. I mean, marriage is something I have seen basically be used as a fraud to take advantage of these people. So when the case is appropriate, I will ask for those powers to help make decisions for the proposed conservatees, for the developmentally disabled adults. But typically, we just ask for 5. We ask for the first 5 that I had listed. That's what most people want anyways, and usually we get them granted. Sometimes we do not get them all, but I'd say 90% of the time we get the 5 powers, insofar as these are typically shown as appropriate, and the parents have typically been doing this for the child's whole life, and we're able to demonstrate that there will be an ongoing need for these types of decisions. So, beyond that, what's the process like? There's a whole bunch of paperwork that gets filed. Petition for conservatorship, confidential information is provided about the background. The people who are going to become the conservators sign paperwork showing that they are aware of the duties they are about to undertake. So we get all of this big stack of paperwork together. You can usually find good lists for what exact documents you need if you go to the California courts websites. It's usually cacourts.gov or some derivation of that. You should check those out. So you get all that paperwork together. You provide it to the court. And in this paperwork, you're basically letting the court know, hey, we have a developmentally disabled adult who needs decisions made for him or her. We are showing why they need decisions made, what the source of disability, how the disability manifests, and I usually give a walkthrough of the day-to-day life of this individual to show just how many decisions the parents or the proposed conservators are making for this individual. So we also provide background information on the proposed conservators. I mean, we have to provide SSNs, we have to provide if there's been any criminal history, bankruptcies, because we really want to make sure that the person who we are appointing as the conservator or conservators, that this individual or these individuals is not going to pose a risk to the conservatee. This person could be very easily preyed upon, and the court's going to do a lot of extra research into the background of whoever we're appointing as the conservators. Typically, this is no issue, as it's, like I said, parents who are caring for a kid, but we have to be careful. So we file all the paperwork with the court. We provide notice, aka send a copy of the petition to all of the proposed conservatees' relatives within the first degree. What does that mean? Parents, grandparents, children, grandchildren, siblings. Doesn't mean aunts and uncles, doesn't mean cousins. It means the individuals who I listed. We send them a copy of the petition and a notice of the hearing date. In San Joaquin, where I practice, you typically get a hearing about 60 days out, 60 to 75 days out. Some counties it's a little longer. It also just depends on how the docket is. It ebbs and flows throughout the year, but I'd say 2 to 3 months is pretty much a good baseline for how long it usually takes. There are other methods that you can get conservatorships more quickly, but courts are loath to grant them except in extreme circumstances. These are temporary conservatorships and ex parte conservatorships. We're not going to go into those too much today. Just know that they're there. If you need a conservatorship in a rush and you can demonstrate an exigent emergency, you might have a chance at one of those. But typically it's better to just plan ahead and go the limited conservatorship route with the 2 to 3 month wait time for the hearing. So we send everyone a notice, let them know that they can attend the hearing if they want. It is a public event, so and anyone can come, anyone can see what's going on. In the meantime, in between from when we filed everything in the court date, the court will appoint an investigator. The investigator will come out and meet with the proposed conservator and conservatees, look at the house, make sure everything looks safe, clean, make sure the conservatee is groomed. Basically, do the due diligence on behalf of the court for this situation to make sure that we are setting everything up for success, that the conservatee is going to be well cared for and that they are going to be protected, etc. Part of this process also is we need to make sure that the proposed conservators have at least reviewed the conservatorship handbook that is issued by the state of California, and they actually sign off on documents saying that they did review the handbook or at least receive it. In some counties, there's even a video that the proposed conservators are supposed to watch before the hearing date. Sacramento, for example, is a county that has the required video. San Joaquin, Stanislaus do not require it. So you're going to want to check local rules, the local court rules for wherever you are filing. So the court investigator will come out and check everything out. Usually an attorney is appointed for the proposed conservatee as well. In San Joaquin, we typically have the public defender appointed. In Sacramento, there is typically an attorney appointed by the court who is a private attorney. This makes a big difference in cost because the private attorneys will charge by the hour if the conservatee or the conservator can afford it. If they cannot, the court will take care of those payments. But out here in San Joaquin, you don't have that sort of billing because the public defender is the one who is dealing with it. So the conservatee will have his or her attorney appointed who will also be there at the hearing just to advocate for or against the conservatorship or for or against the conservator. So we do these things. We provide notice. We personally give a copy of the petition and the notice of hearing to the proposed conservatee to make sure that they know what's going on, to make sure they're aware that some very important decisions about his or her rights are going to be made. So assume all of those things have been done properly. You're going to want to check the court's probate notes. These are usually issued 15 days ideally, 20 days ideally, realistically maybe 2 days, 3 days before the hearing, letting you know what you need to file, if there are any procedural defects that the court wants you to answer to before the hearing. So you go on in. Typically the hearings are very simple. Typically the judge just says everything looks good, we're prepared to grant this. Sometimes the regional center, I found regional centers have been getting more and more conservative about recommending conservatorships. Sometimes they'll come in and say, hey, we only approve 3 of the 5 powers you've requested, or we only approve 4 of the 5 powers that we've requested. Some courts will appoint or will set a small trial to resolve this. Most of the time I'm able to resolve it just at the hearing itself, where we will just let the judge look at everything. It'll take 15 minutes, and if there's a discrepancy, we'll sort it out. But most of the time, none of that happens. Most of the time, it's a very quick proceeding, 5 minutes in and out, where the judge will call everyone, say, this looks good, order granted, you're done. Okay, there are a few other complications that can arise at this stage of the game. The one that I've run into the most is that in Sacramento, for instance, the court has not appointed counsel yet. So usually I get these done in one hearing in San Joaquin and Stanislaus. But in Sacramento, I find that I always need to appear at the first hearing where the court will appoint counsel for the conservatee, even if I file the documentation beforehand requesting that this person be appointed counsel. Still, I find it's 2 hearings. You go in, get the attorney appointed, then at the second hearing, it's a quick 5-minute deal and you're done. So then there's follow-up. The court usually likes to check in every year or every other year to make sure everything's going well with the conservatorship, make sure that the proposed conservatee, who is now the conservatee, is being treated well, etc. And so that's basically a really quick, really rough overview of beginning to end, how the conservatorships work, what you're going to have to deal with, etc. I'm going to provide a lot more information on my website as I get the time to continue updating my blog. You can check out my website in the text below this video, and I really appreciate you watching it through. Thanks so much. Bye.